So welcome, Eric. Eric Wechselblatt from Holland Knight. Thanks for joining us today. I think we got to start this with our typical toast, a virtual coffee with Software Equity Group. Eric Wechselblatt, Holland Knight. Good to see you, Eric. Yeah, absolutely. Before I have you introduce yourself, I just want to maybe set the stage a bit. I've been very fortunate. I think it was 2007 when I first met Eric on one of the deals I was working on. And I think I've had Eric on my side of the table on easily 24 software M&A transactions, where Eric was hired by my clients as their M&A counsel. And so I've had a front row seat to watch him do his thing. And both my former clients and I would agree, it is awesome to watch. So we're very lucky to have Eric with us here today. Eric, why don't you go ahead and introduce yourself, and then I'll go ahead and set the stage for our session. So Eric, to you.
Sounds great. Thank you so much for including me in this. My name is Eric Wechselblatt. I am an M&A lawyer. I've been doing this for about 25 years. I work for the law firm of Holland Knight. I am deputy section leader of the firm's business section, which is about 450 lawyers. We have about 200 plus, about 250 M&A lawyers. We do somewhere in the nature of 250 to 300 M&A deals a year. Last year, according to some of the deal lists, we were in the top 20 in terms of number of transactions under $250 million.
Great. Well, thank you, Eric. So the purpose of these virtual coffees is to meet with industry gurus like Eric, and to obtain insights that'll be of real value to software operators. So today, I want to explore in a short discussion. We try to keep these to 10 minutes, but we've never been successful, or I have never been successful. And Eric will fail today as well. The things that operators, SaaS operators, software operators should do now from a legal perspective to prepare for an exit that may be 1, 2, 3, 4 years down the road. And I've got 4 areas I'd like to cover. And these are employees, followed by technology, customers, and then tax. So to our viewers, sit back, enjoy. Eric likes to talk extremely fast, so I'm certain we will cover a tremendous amount of material in a very short period of time. So with that, let's get going here, Eric, and let's start with some guidance that you would provide to SaaS operators today as it relates to employees.
So let me start by saying, with regard to all 4 of these issues, every company is a little bit different. I'm going to try to talk about nuances between companies, but ultimately, this is really kind of general advice. With regard to employees, whether big company, small company, having proprietary information and assignment and invention agreements with all your employees is something buyers just expect you to have. They don't have to necessarily have non-competes in them or non-solicitation provisions in them. Some buyers can get themselves comfortable if only technology people, developers and the like, have those agreements, but there's no reason not to put them in place. If you do them right, they're enforceable in all states, including California. The second thing, and I just touched on it, are non-competes, non-solicit agreements. Buyers like for key people, whether they're key senior managers, key salespeople, and others, to have non-compete, non-solicitation of customer agreements. As I just mentioned, some states have different rules with regards to non-competes. California and some other states are strongly against enforcing those types of agreements. They're not enforceable in California. And so you really have to consider state law. It's often easier to get employees comfortable with non-competes with niche software businesses, right? Because if someone is not an expert in all cyber areas, having them agree to a niche cyber technology non-compete is different than saying you can't provide services to the federal government if you're a government contractor. So a lot of times it's easier to get people to sign those kinds of non-competes. The third thing I would mention that buyers really focus on are whether you have your employees properly classified as exempt versus non-exempt. When I look at an employee census, if I see 47 employees or 147 employees and every single one of them is salaried, probably some of them should have been hourly. And there's a bunch of legal reasons buyers get very nervous about this issue. So having somebody take a look at that in advance, well before a deal, trying to classify people properly and not running into that issue is something highly recommended. And I guess the final employee issue I think people should think about when they're getting ready for sale are employee versus independent contractor issues. If you have people who only work for you, who work 30 hours a week, only for you, who do the same thing as your employees, calling them an independent contractor usually won't fly. And that can create tax and benefits and other issues. So kind of getting that classification right on the front end is worth it. And again, those are very highly diligenced areas. So buyers get very conservative on those points.
Yeah, and I think, Eric, I want to comment on one thing here. When we're thinking about deals and we're going through a process, my job obviously is drive value, find the best buyer, find the best relationship, de-risk the deal. A lot of these things that we're talking about today are things that can be fixed, that in many cases it's not necessarily something that'll kill the deal, but it's a death by 1,000 paper cuts, and eventually you bleed out and you also get deal fatigue. And so it's really important to listen to what Eric is saying on these items. There's just no reason not to do the cleanup and to get these things proper and in place when you begin, or 2, 3, 4 years before you begin a process. It just makes the process smoother, and you don't run into issues that end up being something that are really bigger than they should have been. So let's move on to the next topic. And the next topic after employees is technology. So what guidance and advice do you have for the listeners around technology?
Sure. So this is probably the most important area, and there's legal and there's business and there's tech diligence associated with technology. We're obviously just focusing on the legal. And Alan mentioned that, a lot of these employee issues are not going to kill a transaction. Very infrequently will these tech issues kill a transaction on the legal side, but every once in a while, there are some real problems that come up with regard to IP ownership. And really, that's what we're talking about. We're talking about tracing IP ownership. A buyer wants to make sure that the IP you say you own, you actually own. And the IP you say you license, you actually license. So we've already talked about proprietary information assignment of invention agreements. I don't want to go too far back into PIIAs, but ultimately employees technically already assign everything they do for the company to the company as a matter of law. Buyers like it because it's a check the box. Mm-hmm. More importantly, however, if you use consultants, whether they're individuals or entities, consultants don't necessarily automatically assign something they create for a business to the company. And so it is really, really, and talking about these other issues, it is really important that every consultant and independent contractor who's involved in the creation of IP sign an independent contractor, an assignment of invention agreement. I have had situations, one a long time ago, one more recently, where people came out of the woodwork and literally asserted that they owned IP that a company said that they were selling just to hold the company hostage. They were shocked that the deal price was $100 million. They felt like they were really involved and critical, and they saw an opportunity. And getting those I's dotted and T's crossed is really, really important.
Yeah, you do not want to be held hostage.
Yeah. The third area I would mention, I'm not an expert on this, we certainly have experts on this, is use of open source. Buyers really want to make sure, especially copyleft, that you're using open source properly. Ideally, your company is keeping an open source log. You're telling your developers, you're telling your consultants to make sure that if you're using any open source in the code, that you keep a list of what open source is being used. Buyers will actually hire a company. The most common is Black Duck, to do a code search and see if you're using open source and see if you're using it properly. So knowing what you're using is great. And then the final item I would mention that I see come up repeatedly is sometimes companies create functionality for certain of their customers. And you need to be really careful in your customer agreements when you're doing that you own whatever IP is created. Sometimes there's a little bit loose language in customer contracts when that occurs. And a lot of times that functionality is reused. And so you can see a concern a buyer might have that the customer owns that functionality and that you've improperly reused it.
All extremely good points. All can have massive impacts to deals. Can, as Eric said, worst case scenario could kill a deal. if I see a lot of risk as a buyer and I'm concerned around this, it's going to change how I look at the deal from a term standpoint as it relates to, indemnities and whatnot. Again, simple things that can be done today. Make sure you're getting them done such that you can avoid the risks down the road. 2 more to go, and we're moving quickly through this, which is great. The next one we're going to talk about is customers and contracts. So let's hear what you got to say about customers and contracts, Eric.
Sure. I told you I talked fast, by the way, or Alan told you I talked fast. So I
But
often
I
can
gotta
get
tell
through.
you've mellowed with age.
I often can get through a lot of information very quickly.
That's
So with regard to customers, I view customer contracting as blocking and tackling. I know smaller companies do what they need to do to get revenue in, and buyers expect that. At the same time, companies need to keep a number of things in mind. The first is, if you have big customers who have a lot of leverage and you end up having really highly negotiated customer contracts, someone, whether it's your lawyers during the M&A deal or someone before an M&A deal, really needs to keep track of what the terms are of those customer contracts. You might agree to various terms, like contracts that require consent in connection with an assignment. So if you sell assets of your business, you're assigning those contracts, and you might need consent from those customers. And if you're selling stock, you might have a provision that says you need the customer consent in connection with the change of control. To the extent you can avoid those things in your contracts, especially when you have customer concentration and big customers, that's really important.
Yep.
Similarly, and maybe even more importantly, big customers sometimes want most favored pricing provisions. They want a provision that says, I get the lowest price. They might say, if you're doing business with me, I don't want you doing business with one of my big competitors. So they might want some type of exclusivity or non-compete. And those things happen. And sometimes when you're bringing in revenue, it's a good decision, but buyers really don't like those provisions. They especially don't like those provisions when they say that neither the company, your company, or their affiliate or its affiliates will do these things. Because if a buyer buys your stock, the buyer becomes your affiliate. So let's say your agreement says, fine, I'll take your piece of business. It's $1 million piece of business, but I won't do business with company ABC for the next 2 years. Buyer buys you, and buyer already does business with ABC. And if that non-compete says, I won't do business with ABC, neither I nor my affiliates will do business. Well, wait a minute, buyer can't buy you. And so we don't see that issue come up, but when it comes up, it becomes really problematic. When you have small customers, you have much less customer concentration risk. A lot of times people don't really heavily negotiate those contracts. A lot of times we see click-through agreements. And if all of your contracts are click-through agreements, it is such an easier process in M&A, right? Buyer knows that you have a set of end user license agreements or click-through agreements. If you can keep track of when you change those end user license agreements, those click-throughs, so that you know which customers are on which click-throughs, your customer diligence becomes much more simple. We really recommend that as soon as you start thinking about M&A, you start going through those customer agreements, whether it's you, whether it's lawyers or paralegals helping you, and you try to make a list now, because you're going to have to make it at some point, of our contracts, our start dates, end dates, whether you need consent in connection with the change of control, whether you need consent in connection with an assignment, whether you have these most favored pricing provisions, non-competes. And the last item are caps on indemnity. Buyers like to see provisions that say you can't be liable for consequential damages. You can't be liable for more than the customer paid you. Obviously, when you have bigger customers, you might not have leverage to fight on those points. But if you have more caps, the better. And frankly, if you know which contracts are capped and which ones are not capped, it's much easier to discuss it during diligence and to make a much smoother process.
Absolutely. So this is really important. I mean, the number of times I've heard clients say, so wait a second, I got like 1,000 customers and 1,000 customer contracts, and I got to find all of them. I got to know what's in all of them. Just imagine the scenario where, as you're growing your software business, you create an Excel sheet or you have some form of a piece of software that does this for you, and you identify all the key terms that exist in your contracts and check the boxes if it matches with this customer in this column with your standard provisions. The new one that gets signed the next day, it has a deviation from the standard, you just note it. Now you've got some way of tracking this thing in a file such that when the day does come that you're in a process, you can hand that over and then they can go and look at all the various contracts that exist and not waste their times with the ones that are just standard. So simple if you're doing it in real time, absolute nightmare when you're trying to do it during diligence. And what do we know? Time kills deals. And so you don't want to be wasting your time in diligence with this kind of stuff if you can avoid it before you get there. Okay, last item is tax. And tax, we could talk about a lot of different things here. But in the interest of time, we're going to limit it to really one item that seems to come up in all deals and has been for as long as I've been doing this, which is sales and use tax. What advice and guidance, Eric, can you provide to people, to software operators today around sales and use tax?
Yeah, so before we jump into sales and use tax, I would just mention that there is a lot of tax diligence in these deals. We're not hitting, as Alan mentioned, a lot of other tax issues. So if you're an S corporation, making sure your S election is good. If you're an LLC, making sure you've been properly issuing K-1s, and that if you have an employee, that you're not paying them as W-2, you're paying them as K-1s if they're an owner. Those types of issues, there's a lot of blocking and tackling to be done. And I would say at least a third of the diligence in these M&A deals is tax diligence. Mm-hmm. But putting all of those issues aside, because we could talk for an hour on just tax issues in M&A, a lot of transactions, and I would say in under $50 million transactions, 75% of the companies I see haven't been paying sales and use tax. And the ones that have been paying sales and use tax maybe looked at it a couple of years ago and the law has changed. So ultimately, the law basically says that certain states can, if you have nexus or enough connection with that state, tax your software, whether it's SaaS or whether it's delivered, and state law really varies. Yep. Basically, what you have to do is you have to figure out first whether you have nexus with those states. Nexus used to just mean that you had enough touches with those states. So if you had an office in those states or employees in those states, or you sent your salespeople to visit customers enough in those states, you'd have physical nexus. And if you had physical nexus in those states, and if that state taxed what you do, whether SaaS or otherwise, then you might owe sales and use tax in that state. Basically, the law changed to add this concept of economic nexus. Economic nexus means that even if you don't have physical nexus, enough touches to that state, if you have customers in those states and you have enough revenue, and frankly, some states have adopted some transactional nexus. So if you have smaller customers and you do enough transactions in those states, you could also have nexus in those states. And therefore, you might owe sales and use tax in those states as well. Not every state taxes SaaS software. Mm-hmm. And frankly, some cities actually do. Chicago and some other cities actually have some statutes. We try to make this really, really simple on clients. We basically do a quick call with my sales and use tax guy who's super. He understands your business. He learns about your business, understands it, figures out which of these tax sales and use tax regimes you may or may not fall under, figures out which set of states we're worried about, and then asks a bunch of questions about where you have your revenue and where you have physical touches, creates a spreadsheet, figures out where it's crystal clear you owe sales and use tax, where you may or may not owe sales and use tax, and where you don't. And for what it's worth, in every transaction, a buyer is going to do the same analysis. If you've done this analysis and gotten it right, it saves a lot of headache. And in those gray area states, it gives you a lot more leverage to say, look, we've been looking at this for years. We have it right. We don't think we have to pay in those gray area states. And so it really, really helps smooth out the deal process. The last point I'd make on sales and use tax is you can write your customer contracts to say that your customers have to reimburse you for that sales and use tax. Practically speaking, people feel very strange about collecting it from their customers, but if it's in your customer contract, it's great to have the opportunity or the ability to potentially collect it from them. And if you're doing business with states or local governments, they may be tax exempt. And it's a little bit harder and a little bit more work to do the sales and use tax analysis when you have state and local and you might have sales exempt tax customers. And so doing it in advance is really helpful.
But you still
100% of the time, this will be something that is diligenced. Getting it right is really valuable. And I said it was going to be the last point, but it was customers. But one last point is that in a lot of states, even if you haven't been doing it right, you can make voluntary disclosures in those states. Those voluntary disclosures will cut off penalties and interest, and those voluntary disclosures will cut back the statute of limitations. Some states will say, you've been doing business for 8 years, you're liable for those 8 years. You can certainly fight that. If you make a voluntary disclosure, the state might say, look, we'll take 3 years of the back sales and use tax, and we'll call it quits and not worry about anything else you've done in the state.
right.
So
Sorry, Eric, but I was going to say, I think it also is, it's dependent upon what type. You mentioned earlier, let's say you're the type of with a click-through license. You got a high volume business, lots and lots of customers versus maybe somebody who is another company that's got fewer customers, but much larger deals. How you handle and how you deal with this stuff is going to likely be dependent on what type of market and customer that you're serving. You may be asking for the money from your customers, or you may have something in your contract that says that it's the customer's responsibility. If you do have that, then you need to have some form of proof that the customers were self-assessing, that they were paying, that you can then keep track of, such that when you do get into diligence, you can say, yeah, here, look, these guys have been paying. Here's the proof of that. And what are we trying to avoid here? What we're trying to avoid here is some form of special indemnity or some form of an escrow of monies that are going to be set aside in case there are issues down the road, or when the buyer goes into some form of a voluntary process to make sure that this is done properly and correct. It's not going to get ignored. It's just not going to happen. And so don't bury your head on the sand on this one. Deal with it head on while you're operating your business, such that when you get into diligence, it's a non-issue. And when we do work with clients where they've been handling this, I got to tell you, it's really smooth. So, Eric, anything else before we wrap this up?
Yeah, so Alan, you hit the nail on the head when you said time kills deals. So ultimately, if Alan does his job right, which he always does, if there's competition in your transaction, if there's multiple buyers, and we can keep buyers moving quickly through the process, and we tell them, look, you have 3 weeks to do your confirmatory diligence, and your diligence is crystal clear, we can get through that in 3 weeks. There's less likely to be some other hiccup in your business. There's less likely to be a problem. And so if you hit all of these items, most of these items, some of these items, you're just speeding up the process and significantly reducing risk. You're also probably saving legal fees by doing this upfront. That's not always the case. But the fact is, when you're in triage mode in an M&A deal and buyers bringing up something you haven't thought about, you're spending more money on legal fees fixing it at the last minute than you would be if you fixed it up front.
Not to mention the deal fatigue that you as the seller are going to experience, that's just going to cause other issues as part of the process. So this has been fantastic. I really hope those that watch this really take note of what Eric had to say. There's just so much content here, and it is so valuable and so real. He and I have lived it. We've lived every side of it, from the good, the bad, to the ugly. We really think that this is the kind of guidance and advice that we can give to you that will make your life a lot easier. So with that, Eric, cheers to you. Thank you so much for joining Software Equity Group today in virtual coffee with SEG. This has been fantastic. And we look forward to continuing to work with you down the road. Thank you so much.
Thank you. Thanks for including me.
Cheers.
Cheers.